So, hi everyone. Today is a day filled with joy for the arbitration fraternity. The Supreme Court has delivered a landmark ruling and overruled its previous judgment delivered in NN Global. The five-judge bench judgment in April 2023 brought to a light a multitude of legal issues that required immediate addressal. And today, a seven-judge bench held unstamped agreement to be unenforceable but not rendered them void ab initio. It will be safe to say that today's ruling will be promote pro-arbitration culture in India. On this day, we have with us counsels for petitioner, Mr. Debesh Panda, an advocate on record at the Supreme Court, Mr. Naman Maheshwari, an advocate practicing in Jaipur and Delhi, Mr. Garv Malhotra, a partner at the arbitration firm Skywards Law. Also, it is important to mention that all three of them are alumnus of the prestigious MITS LLM program in Geneva. We can say that life has come a full circle for all of them as a team. I also would like to thank Ms. Prachi Bhardwaj, Senior Associate Editor, for joining in this interesting conversation. Over to you, Prachi.
Thank you, Bhumika. It is indeed a pleasure to connect with the amazing team behind the historic judgment today. First of all, congratulations to all of you. So I would
Thank you
like
so
to
much. Thank you.
Thank you.
I would like to start with Depesh. Today, the seven-judge bench held that the unstamped agreements are inadmissible but not void ab initio, and that the courts are to be kept out of the issues relating to stamping of agreements. So, can you elaborate upon this and break down the key takeaways of the judgment for our viewers?
Um, Let me first start by saying I don't think any of us has fully read the judgment cover to cover yet. But I think the biggest takeaway for us today is the fact that it's a unanimous judgment. And I think that says more than what you would like to, think about it. I think the first reaction is the fact that it's unanimous. Um, I believe the statutory mechanism was always there. And this is all it said. It didn't go a step further. I think the confusion happened because of the way, different interpretations came in over different points of time. They created layers in the law. So I think the exercise was more of removing these layers and looking at it from a bare bones, how does the act deal with it? And I think when we were preparing for the five-judge bench, this is basically what we had summarized it for the court to say, this is a case where the Arbitration Act intersects with the Stamp Act. The Stamp Act is a British era law that has existed since 1899. You've had thereafter a modern, law for arbitration under the UNCITRAL model of 85. And when we introduced that into our statute book, when the Parliament did that, Parliament added extra layers of protection. And it's those extra layers of protection that had to really be given meaning, because you were seeing one law intersecting through an old British era law intersecting with a modern law. And what we felt when we had argued before the five-judge bench was that you have all these things uh, which Parliament is conscious about. Otherwise, it wouldn't have put in these extra layers of protection. What was necessary was to give them meaning. And those are departures. Each of those departures had to be given some meaning. And I'm very happy to say, I mean, when we were listening to the judgment get pronounced, one of the most important developments for arbitration law, I would say, and this is something that's going to really help in the years to come, is that the court has given meaning to Section 5. So 5 is like this innocuous little section that's always been there in the Act. But you've had very, very few judgments that have really dissected 5. And today, for the first time, we heard the Chief Justice, when he was pronouncing the judgment, say that 5 will become redundant if you don't do this. And that is what we had always felt. So I think my two biggest takeaways from today, without having read the judgment, is A, it is unanimous, and B, they've actually given flesh and blood to Section 5, something that was always there. Finally, you see it coming to life today.
Thank you so much, Mr. Panda. Naman, coming over to you, can you please tell us the impact of this judgment on ongoing cases and the offshoots of this case before High Courts?
as Devesh also said, impact is immense actually for the arbitrations all across India because as you can see, right from the time when NN Global was delivered, the whole country was actually stuck because arbitrator appointments were not taking place because anytime an objection would be raised that the stamp duty was not paid in an arbitration agreement, the court was straight away rejecting those cases. And because the NN Global had authoritatively said that no arbitration can proceed until and unless the stamp duty is paid, the courts were invariably asking all the litigants to first pay the stamp duty and only then you could proceed for the arbitration and appointment of arbitrators. And this saga started actually from the times when SMST estates was delivered by the Supreme Court, and then the Parliament thought it wise to insert Section 11(6)(a), which then confined the courts only to the existence of arbitration agreement. But unfortunately, Garware wall ropes and then this NN Global judgment again added a layer of obstacle for the arbitrations to proceed. So it will be a big impact today for arbitrations all over the country to proceed in a seamless manner.
So, do you also think that may create some kind of chaos uh, in the coming cases, or will it be applied very clearly?
Can you please elaborate on what you mean by chaos and how it will be a chaos?
The chaos in terms of that, as you said, that earlier the courts were themselves saying that you should go for first for stamping and then come. And now the people do not sometimes, apply the cases correctly. Even the advocates miss it, because which is why Section 5 was going on the verge of being redundant. So, will it now be a smooth sailing from here on?
Of course, because now since this has become the law of the land today, so and media these days is very, very active, so everybody knows what is going on in the country, and the day the judgment comes, that is the time when everybody knows that this is the law of the land now. So I think from tomorrow onwards it will get very smooth, because all of the law which has been now developed by various high courts during the period of NN Global and this curative petition will be actually put to rest, and from now on we will have some smooth appointments of arbitrators.
Very well. Uh, Debesh, this is also one of the first cases where the new guidelines for written submissions before constitution benches has been applied. So, how was your experience preparing for this case, and how does one generally prepare for such larger bench cases?
Um, so I think first thing first, couldn't have done it without the support of Naman, Garv, but I literally had an army behind me. I think very candidly, I will say couldn't have done it without all the support. I think more than anything, I've told people today, people are asking me, how did you pull this off? I said, you have a clerk. I have a clerk. His name is Pankaj. He's the Rock of Gibraltar for me in my practice. And I mean, people like this who will make sure that, you don't skip a beat when you're working. I think that's the biggest secret to success. I will say that's the secret sauce. But overall, I think it's very helpful to see what, the changes that have come in because of this new circular that the Chief Justice has introduced. What we did different, I think, in this was Preeta was the nodal counsel, who was my counterpart for the respondents. And Preeta and I are both from the same law school. So we have a comfort zone with each other going back, I think, a long time. And one thing we all agreed upon very early was we are going to automate the whole process. So we created a Google Drive, and I said it's going to be free for all, public viewing for everyone. You can't delete things from it. And so if you put things, take it, it'll be visible to everyone. Put out a very clear sort of a internal SOP, I would say. which mirrored the Supreme Court's SOP to say, feel free to put things on it. We are creating Google Forms. Whatever you put in will be visible to the whole world. And we use the same structure as the circular. So we created 5 folders saying volume 1, volume 2, volume 3, volume 4, volume 5. And I think kudos to the fact that counsels who were in the matter were incredibly supportive. What Preeta and I had both apprehended was there'll be quite a bit of blowback saying this is too much tech. And I thought, no, I think people are going to be okay with it. Let's try it. I mean, let's see if there's a blowback and then we'll deal with it. And I think it's in the same spirit and what the Chief Justice has been doing in the last year. Let's go, let's be open to technology. Let's try to automate things. Let's make things simpler. And I'm very happy to say this, not one counsel complained. I think credit goes to, all the members in the fraternity. They've been so open-minded about it that, I mean, we did a little bit, which we could, Preeta and I and the entire team, but it was over to everyone else to say, do we accept this or not? And I can just say sitting here today that it was overwhelming to see how people responded saying, yes, it's the right thing. I mean, I've sent screenshots from that Google group that we created, for everyone to communicate on. People had such kind things to say on that. I think more than anything, my dad was very happy when he saw that saying, good, this is how you make people get used to working with technology. So yeah, I would say A, an incredible bunch of people who are always there to help, and B, technology, if your mind is open to it. And I guess we were lucky because this was arbitration. Um, I don't know if this had been the Article 370 hearing, if people would have shared the same sentiment. And really hats off to the nodal councils in those matters, that those were massive in comparison. But we did the best that we could. And I think the biggest takeaway was the fact that because we automated it and we were very clear, people got a lot of time. And even though things were very close to the deadline, I don't think we once skipped a beat in the entire matter. So everyone went home happy. I think that's how I look at it.
All
Thank
that
you so
ends
much,
well.
Debesh. Yes,
All's well that ends well.
absolutely.
I think that's how I look at it.
And
Just
it's
to
a
give you a
it's a
small
big
I
win you
also
have
anecdote,
wanted to
given.
pick up something what Naman said a while back when you asked him about the chaos. And I think it's very important that a 7-judge bench has laid down these principles, because what they did was they pronounced on Section 8 and Section 11. So the die is cast, and even though the field is open when you come to Section 9 or Section 45, I really don't, I don't anticipate, unless something, something we haven't contemplated, unless that comes up. I really don't see why in the realm of 9 and 45 there should be a significant departure from what the Constitution bench has said. So to answer your question, I think it's going to help soothe, I think, many a ruffled feather in the law as we
Right.
go forward. Yeah.
True.
Right. Thank you so much, Devesh. I think it was a great win. You have given a landmark judgment. It just overruled, the Supreme Court overruled within a year uh, of NN Global, April 2023, and now this day will no one will arbitrators will not, never forget this day. So,
Yeah, I
Garv,
don't think
coming
you
to you.
often see this ups and downs within 1 year. Something started
Absolutely,
in Jan and ended
absolutely,
in December. So quite a roller
absolutely,
coaster it's been
absolutely.
as a year.
Absolutely, absolutely. So, Gal, coming to you, this judgment is a big one for more than one reason. And I don't remember the last time when a 5-judge bench verdict was reconsidered and decided by a 7-judge bench in the same year. What do you think? Where does the credit lies? Is it Supreme Court that is proactively deciding these larger bench cases, or is it the advocates who are putting their best foot forward to wrap up the cases as soon as possible? What are your thoughts?
I think credit in a matter like this lies in multiple corners. It is certainly phenomenal work on part of the honorable judges of the Supreme Court of India. Earlier this year, we had a 5-judge bench disagree with our position of law by a 3-2 majority. And then within the span of a single year, to have that overturned unanimously, that is certainly a big feat. And I think it's towards the larger attempts being made even by the Indian judiciary and the legislature towards improving the Indian arbitration ecosystem overall. I think we haven't read the full judgment just yet, but it is certainly a very commercially pragmatic decision and in line with the larger vision to make India more arbitration friendly. Um, I think the credit also lies certainly with the incredible advocacy of the senior counsels leading us, Mr. Arvind Datar, Mr. Jayant Mehta, Mr. Nikhil Sakadande, with stellar counsels like Debesh and Naman. Naman for sure has been, the edifice of this saga from the very start, hand-holding the client, getting together a legal team, organizing everything, briefing counsels, and on and on. It's just been an incredible journey this year. I have to absolutely also mention my colleagues from Skywards Law, Ishan Chaturvedi, especially, and assisted by Arijit and Arundhati. These guys put a lot of sleepless nights into having all of this come together very well. It's a logistical nightmare at times to have to just do coordination with about 80, 90 councils at the same time. And personally, I think we are also very grateful that in this matter, we got a lot of stellar members of the bar to rally behind the cause. A lot of very renowned people from the arbitration community came together, gave stellar written and oral submissions. Mr. Gaurav Banerjee, Mr. Nakul Diwan, Mr. Darayas Khambata, Tejas Karya, Kunal Vajani, so many of the stellar councils spent thousands of hours this year pro bono just because of the passion for the subject of arbitration. And it's certainly a very bright day for all of us whose hard work has come together in this judgment.
Absolutely, absolutely. And as you just mentioned that Naman kind of, if I can say so, led the march in this particular case. So, see, a lot of young lawyers and law students, of course, they look up to the senior counsels and the big names for inspiration. But really, the true inspiration comes from young faces like we have today with us. So, can you just share some tips for our audience, like how to prepare for big cases like this, and also how to stay grounded after such a big win?
I think we have not achieved that many heights so far. So we are still grounded and we don't know. But let me first of all give you an anecdote, and that is where I want to begin to your answer. So Mr. Debesh Panda has sacrificed his holiday, entire holiday, for setting up this whole case and to see that the coordination among the members of the bar was fine and clear. So he sacrificed the entire holiday. I don't know how much trouble he faced in his family, but overall, as far as the as far as the official aspect was concerned, everybody was very happy with the team. So this is the kind of effort you actually need to put when you think about big cases, and at least at the Supreme Court level, because there is a lot of preparation which needs to be done. There is a lot of hard work, research, which really requires to be done, and multiple conferences we have had with various seniors at various times. So that was to see who is going to argue what, and precisely what is the line of argument which you want to start with. So this is the kind of precision which is required, and for this, if you need much clarity, you need to put a lot of hours. So this is the tip for all the law school students and those who are willing to work in this fraternity. It requires a lot of preparation. That is number one. And number two is, I think, if you have great team support, that is what works well in your favor. So if you have entire team, because this is not a one-man show, this can never be actually. All the constitutional cases require a team effort, and if you have a good team, I think you have more chances of winning the case.
Thank you so much. Thank you so much, Naman. And again, coming back to Garv. Garv, do you want to share anything else? How are you feeling? Any words with our viewers?
I think this one was a very special one because this is a journey that came full circle. It started in January, and as we are closing this year, something that we were very heartbroken about. I think the whole arbitration community was heartbroken about after we got the decision in NN Global. It's wonderful to see this come together. For us, I think for Naman and I, it's even more special because we, in this matter, got the chance to work with our own senior. Naman and I both started our careers from Debesh sir's office, and working with him and through him, and working with some of the finest counsels in the country, it's always truly a privilege. It's because of the stellar support that all of us have the privilege of getting from our teams, that we are able to do this. Unfortunately, you guys can't accommodate like 30-40 people behind us on this call, so they aren't here, but they deserve to the credit for this just as much as we do.
Thank you so much, Garv, and thank you, everyone. This was indeed a great interaction and a lot to take away from here. And thank you all for being so clear and honest with your responses. And congratulations once again, and all the best for your upcoming cases. Uh, I think it was a great interaction and very quick interview. You have given us very nice words about all the hard work which you have put in. Thank you once again.
Thank
Thank
you.
you so much. Thank you.
Thank you, everyone.
Thank you. Thank you.
Thank you.